Welcome to the Zebra Family channel. If you have not subscribed, please click the like button, share and subscribe. It's free. Family, I'm back again. I'm back again, family. Zebra family, I'm back again. Oh my God. Rata opened a tavern in court. I can't believe Rata did what he did. I am trying to understand who is Rata trying to protect. Because every time when the advocates are asking questions to witnesses, it's like to Rata there is a no-go area that he has. Like, lo mbuzo lo hayi angifuni awubuze because uzosifaka problem. Aba basithumile ukuthi senze umsebenzi wabo ngathi sizolahlekelwa yiloko abasinikeza kona. Angazi ukuthi kwenzakalani impela kuRata. Can anybody explain? Because Rata now, the judge, has tend to be something else, more special. Today it was even worse. He did it to Mgomezulu, trying to interject Mgomezulu, not listening to what Mgomezulu was, to what point was he driving in court. Because Mgomezulu has been saying, Advocate Mgomezulu, he's been telling us that this is cooked evidence, and he's busy poking holes. And the holes that he's poking to this evidence, and it's becoming clear to any layperson out there to understand. Even the witness was really welcome to the Zebra.
All you can confirm is that the number of the device was at a certain location, but he can't vouch to the fact that the device which belongs to Rachamo Kwatling was at that location. Am I talking correctly?
Let me clarify this by asking this question, by telling this, by putting this to Mr. Stein, Mr. Host. I had an opportunity to consult with the rest of the accused. It is confirmed that accused number 3 was in possession of this device on the 26th of October 2014.
Where?
On the day
Where?
of, my lord, may I just...
No.
I don't want to leave the gates.
No, Mr. Mgomezulu, please.
I started, my lord,
The court must be placed in a position to understand. Because
My
this
lord.
witness, wait. This witness doesn't talk about locality of a person. This witness talks about the locality of a device. Mr. Host, Colonel Host, it's a graph.
That's correct, my lord.
That's it. So I
But
must
we're
understand.
talking about the accused
Otherwise,
number
this
3.
court is a Mickey Mouse court.
No, my lord, no. The court must not dig its own way
No,
of finding the person. No, I'm saying there's evidence here. GG.
Yeah.
It talks about accused number 3. The instruction the request that was made to Mr. Host was in relation to 5 accused. Accused number 3 is one of them. And my instruction, when I cross-examined Mr. Host yesterday, I started at 7 in the morning. Yes, in page 10, until the 30th of October. There's no other accused person that I'm talking about.
No,
I'm talking about...
But listen, I was in this court. This witness never confirmed the presence of accused number 1, 2, 3, 4, 5. He confirms the presence of a number. And it's false. Am I correct?
My lord, this is a section 205 is on the number.
Please.
The IMA of the number where the number was in that area.
The number, not the person.
The device, my lord.
May I request the court...
That's not me saying that. It's him saying
May
that.
I request the court not to be impatient? May I request the court to be patient and
I'm
listen
very
to...
patient.
No, my lord, I disagree with you. I don't want to fight a dialogue with you.
Okay.
My concern is that just now, to correct that accused number 3, I'm putting to this witness now
Right.
that from 8 o'clock, I'm specific now, from 8 minutes past 8, according to these records, he was in possession of the cell phone.
Okay, fine.
Until the 30th. I'm being specific.
Yes.
I don't talk about other days prior. Now I'm putting to you, Mr. Host, accused number 3, I put it as a fact now. You can disagree with me. I put it as a fact that on the 8th, on the on the 26th of October 2014 at 8 minutes past 8 as with reference to page 10 of Exhibit GG, he was in possession of that device. I put it as a fact now.
Can't comment on it, my lord.
Okay.
But you saw us charge of 808 30. Why pet the Makaru Chita and was better the suspense?
Let's now get into your evidence, which I said is irrelevant in this court, 2018. Before I conclude my examination, I'm going to argue at a later stage that evidence that you presented in this court from 2018 to 2021, it's irrelevant in this court in the sense that there's no communication that you have placed on record through either through SMS or WhatsApp that constitute or has the elements of a particular offense, meaning there are no SMSs, there's no communication that you can prove to this court that these accused persons knew each other for wrong purposes, especially in relation to the death of Senzo Mayo.
But a focus on a blade corner and dolo, or what in Shambe Guaban and SMS, no WhatsApp, a commissary to Kumana, one of a soda, Mailana, no Wensage, Holeda, Bulawin, the Senzo Mayo.
Meaning, you cannot prove mens rea or mean guilty mind in this communication between these accused persons.
I was a spoon so what Labag, Abasola, Babe Shosile.
Can't comment, my lord. I don't know what it means, sir.
You can't, I'm putting to you, you can't even prove the actus reus, the positive act in the communication of these 5 accused persons in terms of these records.
My lord, I don't have a law degree. I don't know what
Actus reus is positive act.
he's put statements to me.
No, this is,
I'm new in the court.
let me just give you an example, Mr. House. Just an example. An example would be in the communication, accused number 1 said, yes, this is what I've done through a message or SMS. Yes, that's what I was trying to say. Let's move forward. You remember when you talk about paragraph 15.2.2 in your exhibit DD5?
That's correct, my lord.
You talk about the cell phone that was taken from accused number 1 during his arrest under case number 217-03-2019. Remember it? Paragraph 15.2.2.
Paragraph 15.2.2, exhibition TD5. Ukurumengo, the cell phone at home solo gala, and it's cut a bosh.
Yes, my lord.
But yeah,
Do you agree that you spoke about accused number 2, accused number 1 being arrested under case number 217-03-2019?
Tekhumbula ukuthi wathi lapho umsolo waboshwa ngaphansi kwecala kuthiwa 217-03-2019
Tembisha cash.
Sorry?
Tembisha cash.
That's correct, yes.
wathi icala sethembisa yebo.
When they try to defend their clients, it was worse than ever. Listen what he had to say.
About current case as per original statement dated
2024-0416 in brackets Exhibit DD5, reference page 20 in brackets. Picture was accessed and edited on 2021-01-11. You see that?
That's correct.
And then you say the section 205 data placed Bongani Ntanzi near cell tower 3G Queenswood NGA, that is 220 meters from Valeria SAPS.
That's correct, my lord.
And there's a picture there, I don't know what it depicts, but I'm not interested in it in any event. What I'm interested in is the following. This one that says section 205 data placed Bongani Ntanzi near cell phone tower. What is the basis of you saying that the tower placed the accused there?
Because the tower is 150 meters from Valeria police station. That's the nearest tower that was picked up by the cell phone.
But in there's ukuthi sola untanzo ayelapho ukuthi le tower lena isekuduze kakhulu isikhumulo samapholisa seValeria.
According to the section 205, not according by me.
Akusho mina kusho section 205.
You see, Colonel, the problem now becomes this. You remember the cross-examination of my learned colleague, Mr. Mgomezulu, when he put it to you that accused number 3 was not in force arrest at the time of the commission of the offense. And your response was, you cannot say that accused number 3 was not there. You can only say that the device. You understand that?
So the device was, okay. If you put it to me, the device was in the cells where the accused was also, because this was 220 meters from the cells. So somebody else's phone that was in the cells?
Yes.
Is that what you...
Yes, because the problem becomes when you try to put ready-made inferences by saying a particular person, because he was 220 meters away from this tower, you can now, through the data record, say it is exactly this person that was 220 meters away editing these pictures. You see the problem?
It's a fact that accused number 2 was incarcerated at Villera police station.
That's not disputed, Mr. Speaker. You also admitted that your client was inside the cells at Valeria.
Yes, I do.
So what's the problem? Now I argue the fact that it was not a cell or what, because the facts show that accused number 2 was arrested and incarcerated at Valeria, which is 150 or 200 meters away from that our post. I mean, please. So,
Oh my God. Rather, again, he jump again and open a tavern. He's always telling advocates he doesn't want them to behave like they are in tavern. But today, he opened a big tavern, more than what does advocates normally do when they try to defend their clients. It was worse than...
unless you say what your client was in Rustenburg or Phuket or wherever, Natal or wherever. But you yourself, you say your client was incarcerated in Valeria. And that pole is 200 meters, is it?
220 meters, my lord.
220 meters from the cells. So what are we getting at, please?
My lord, you see, what is good for the gander must also be good for the geese.
Yeah, of course.
Yes. The state cannot, in one instance, they say, no, only the device was here, but the person may have been somewhere
Yes,
else.
they can't say that. But in this case, according to you, your client was in Valeria.
Yes.
According to you.
Yes.
That's it. So what are we arguing about?
My lord, perhaps, you see, my lord, at times, and I'll have to join Mr. Mgomezulu's sentiment. I'm not that kind of a person. My lord has got a tendency to be impatient.
I'm not impatient.
I'm sorry, I had to
quoting
put in my note.
Look, if I'm wrong,
Yes.
I admit, if I'm wrong, I'm wrong. But you yourself, you said your client was at Valeria. And said, unless you say he was not there, fine. Then I withdraw everything.
Because the other evidence that we need to hear, and that's been the trend, we need to hear it from the clients. Instead of the court saying, didn't you say so?
Because he's going to say yes, because the court is validating that answer for the witness.
No, I'm not. Just quoting the evidence as you have admitted.
We are part of this evidence, my lord. We read the same evidence, we hear the same evidence that his lordship is hearing. My lord, it's 1 o'clock. May we take a longer agenda?
And this witness, he can't know where your client was. He can only testify about the device. But me, having listened to you putting the assertions, you said your client was at Velaria. And when Mohano says he got the phone at Velaria, you said to your client, he is not telling the truth. That's all.
That's not the basis.
So allow me excoriated for quoting the evidence.
No, my lord. Let's take the longer agenda.
Then you can listen.
It doesn't. Where's the respect for the, because these are professional advocates. Where is professionalism? When he acts like this, he's a judge. He has to listen to each and every evidence, and the defense take notes, interject where it's necessary, not to defend, because it's like he has the judgment for the accused. What is it that is about Ndanzi? Can anybody explain to me? What is it that is about Ndanzi? That it's like they're tracking Ndanzi. The same judge has forgotten that while Ndanzi was in custody, Ndanzi's cell phone, was picked up in different towers in Joburg, but Ndanzi was in custody. Then now, he was transferred to that prison, wherever he has been kept. In that tower, when it picked, now Rata now is supporting that Ndanzi was in that jail. Does it make sense to anybody? When it suits him, Rata, he talks about it. When it doesn't suit him, it's something else. I'll give example. Mgomezulu yesterday talk about, the witness was saying the cell phone was not in Phosphoras. But Rata rushed to say, even if the phone was not dictated in Phosphoras, but it doesn't mean that person was not in Phosphoras. When it suits him, he likes it. When it doesn't suit him, he doesn't like it. Is this a judge to reckon with? Family, this is up to you. Let's talk about this. Bring our opinions, comment, like, share, but respectfully. And let's not really forget to subscribe button. We press the subscribe button, then I will be bringing you different content about what is going on in court, so that we can all analyze exactly the behavior of the judge and everything that is going on in court. Let's do it, family. Bravo, bravo.